you, Mr. Speaker. I rise to speak on behalf of the Greens on the Justice Legislation Bill 2018 and wish to focus specifically on two areas of this bill. While we see that this bill makes amendments to the Crimes Act, Criminal Procedures Act, Anti-Discrimination Act, Crimes Commission Act, Law Enforcement Act and the Succession Act, I wish to address specifically and focus on two amendments. One, which is the amendment to the Anti-Discrimination Act 1977 to remove exemptions that apply in relation to employment to discrimination against pregnant women, and the other, which is to amend the Law Enforcement Powers and Responsibilities Act 2002 to extend a court's power to order a person found guilty of drink driving offences to have his or her photograph, fingerprints and palm prints taken at a police station to a person found guilty of driving with illicit drugs in a person's oral fluid, blood or urine. May I say at the outset, it is almost astounding to me that we are here amending the Anti-Discrimination Act to remove an exemption that somehow would have allowed women that were pregnant applying for a job to be discriminated against. I don't think that anyone that is a man in this place would ever imagine that in a job interview they would have been asked whether or not their partner was pregnant when they were applying for that job. That might be an odd thing for a man to be asked. But it appears that actually women, in the face of much discrimination and challenges when it comes to equality in the workplace, have been facing that risk, and it is with much pleasure that we see that that is being dealt with today by the removal of that exception. It is with great it is important for me to credit straight up, as the Attorney-General did, the work of my Greens colleague in the other place, Dr Mehreen Faruqi, who identified this as a serious concern within the current laws and raised this issue, and it was as a result of her advocacy and pressure, as well as those, I should say, over many years before, where this amendment was flagged as something that needed to be changed, that we're seeing this change today. In fact, it does seem, according to the history of this, that the exceptions were inserted into the New South Wales Act by the Anti-Discrimination Amendment in 1981 under the then Neville-Wran Labor government, and that this meant that many women were having to take proceedings under the Commonwealth Sex Discrimination Act, which does not have such exceptions. There have been several reviews over time of these recommended changes, but unfortunately to this date none have been implemented. The New South Wales Law Reform Commission in recent times had drafted a bill that would address these pregnancy protections and remove the exemptions, and the Australian Human Rights Commission flagged this as part of their research in 2014, looking at the pervasive discrimination that women face when it comes to pregnancy and the return to work. So for many women in the electorate of Newtown, this is a big issue. We have one of the highest number or highest percentages of working women with young children in the electorate of Newtown, and it is a big issue that needs to be addressed as we address the issue of equality in the workplace. From the moment that women become pregnant, there is a huge gap that widens. Women feel unable to be able to apply for new or more senior roles, or pressure that they can't, and they are often forced to take up more time off work because they can't access affordable childcare. It is the time when male peers start racing ahead of them in their career progression. And just as a personal note, it is interesting to note that the most job security I had as a woman who was in my 30s when I got elected, as a woman was actually when I got elected to the seat of Newtown in 2015. A 4-year set term was the most certain jobs that I had in my 30s, and that gives an indication of the insecurity of the workforce, and I'm pleased now that my daughter Scarlett is 1.5 and cruising around the chamber on a regular basis. But it isn't all people that are this lucky in the workplace, and it is clear that we need to be addressing all laws that address the inequality for women. We must absolutely be seeing provisions in this law that allow an employer to sack a woman if she was pregnant at the time of the job interview to be changed, and removing this legislation will bring New South Wales into line with other states and the federal discrimination laws. A huge number of women in the electorate of Newtown and across New South Wales are discriminated against, and this is one small and significant change that can be made, and I am proud to be a part of standing in this place today to offer the Greens support, and again give credit to my Greens colleague Mehreen Faruqi for her advocacy of the updating of these archaic laws. The other area that I wish to address was the issue that relates specifically to what is an element of the bill that addresses the issue of people being required to provide their photographs, fingerprints and palm prints to police. And that specifically relates to the inclusion of those that are facing drug driving tests. Now, it will be clear to many in this place and in the chamber that my Greens colleague, Dr David Shoebridge, sorry, I've given him a doctor title, he doesn't have a doctor title, I was just talking about Mehreen, she has a doctor title. My colleague in the other place, David Shoebridge, has exposed a multitude of problems when it comes to drug driving testing that have been rolled out in New South Wales, and he will be seeking in the other place to make amendments to what is otherwise a very positive or uncontroversial elements of the bill to be able to remove the testing around the provisions that allows courts to order that drug driving offenders be required to provide their photographs, fingerprints and palm prints to the police. Now, just to explain, the drug driver scheme does not test for drugs known to cause driving impairment and detects minute amounts of other chemicals which cause no impairment. This bill will allow anyone with a positive test, no matter how minute the chemical trace in the saliva, to then be placed on the police database forever. This is a gross infringement of people's privacy and will do nothing to make our roads safer. The drug driving tests look for a minute amount of certain chemicals in saliva, and a positive test can show up because someone has smoked a joint several days earlier. There are reports of people legally using hemp seed oil, which contains almost no THC, failing these roadside drug tests. It is really, the question has to be asked, is it really reasonable that someone who has no level of driving impairment has their photographs, fingerprints and palm prints permanently placed on a police database? Imagine if any single person with any level of alcohol below the legal limit was then mandatorily fingerprinted and photographed and placed on a police database forever. It would be unacceptable if we were talking about people that were driving below the legal limit. But when it comes to drug driving tests, it appears there is a discrepancy, and as I say, the Greens in the other place will be moving an amendment to seek to remove that element out, and I would hope that a recognition of the concern that there is no evidence to back up the current drug driving tests, but also the huge infringements of rights and civil liberties that this would place on people that actually have not demonstrated a level of driving impairment would cause huge concerns to many in the community, and I would imagine that it would cause significant concerns to a number of regional members of this place who would see many of their members concerned about the drug driving testing currently being rolled out in New South Wales and the real concerns about the fact that these are not actually assisting. We know that only 3 drugs are tested for, cannabis, ecstasy and amphetamines, when there are many other drugs well known to cause driving impairment that are excluded from testing. The Legislation Review Committee have looked at this bill, and in relation to this area they have said that collecting such personal information may breach an offender's right to privacy. While the amendment treats drink driving and drug driving offences consistently, a person will only be found guilty of the similar drink driving offence under section 110 if they exceed a prescribed blood alcohol concentration. There is no such prescribed limit with the drug driving offence, and it has been suggested that drug tests in other jurisdictions are aimed at detecting a level of the drug that would affect driving. The offence may therefore capture people whose driving is not impaired by drugs. For these reasons, the proposed amendment may be seen to inappropriately lower the threshold for the collection of personal information. It is clear that this part of the legislation has not been clearly thought through, and it would be such a shame that a piece of legislation that goes to address an archaic exemption that addresses the rights of protecting women in this state would simultaneously add in more infringements to people's rights and civil liberties. I hope that the government will consider the amendment moved by my Greens colleague in the upper house and support it so that we can see an end to discrimination and rights infringement in this bill. Thank you.